everyone, my name is Yulia Vichart and I'm a family lawyer. I work at the law company of the lawyer Alexey Nikolaevich Skrябin. Our law company specializes in providing legal services in the field of divorce and recovery of alimony. Our lawyers provide support in courts throughout Ukraine. In this video, I will tell you about the divorce procedure in Ukraine, the procedure of divorce through the registry office without children, how to file divorce through the court with children unilaterally. Is there a divorce procedure based on the common application of the spouses to the court? How long does it take to file a divorce? When is it impossible to file for divorce? And what are exceptions to the procedure of divorce? Watch this video till the end to know a lot of interesting information about the procedure of marriage dissolution with and without children. Subscribe to my channel and always receive up-to-date information in the field of family law. Contacts for contacting me about paid consultations are under this video. Divorce procedure through the registry office without children. Application. The rules of the Family Code regulate the administrative order, namely how to file for divorce through the registry office. To apply this order, two conditions should exist simultaneously: general agreement to terminate the marriage and absence of common children under 18 years old. This order can be divided into two separate stages: filing a statement for divorce through the registry office and drawing up by the civil registry office of the divorce record. State registration of divorce of the case is made on the basis of a written statement for divorce of spouses who don't have children, who should clearly state they have no common children. Based on judicial practice, the courts encourage the administrative procedure for divorce in the case, when the married couple has no obstacles to this. The procedure for registering a divorce by the Department of State Registration gives rise to the corresponding consequences of a divorce for spouses. The month between the moment of filing the statement and the conclusion of the assembly report of divorce is the period that the legislature gives spouses to see their decision to dissolve the marriage. Unlike the judicial order of divorce, the administrative order leaves without a clear legislative regulation the issue of the death of one of the spouses during this period. According to the provisions of the Family Code, if one spouse dies after filing an application for divorce, but before state registration divorce, it is considered that the marriage ended due to the death of one of the spouses. To file a divorce through a court with children unilaterally. The procedure for divorce through the court provides the rights of everyone to file a claim for divorce, unlike a divorce upon a common statement of spouses with children, and a divorce by civil registry office upon an application of a spouse who hasn't children. It is possible to file for divorce unilaterally on a claim when only one of the couple seeks to terminate the marriage relationship, while the second doesn't want this. In practice, there are cases when at the first view persons can dissolve the marriage in the manner prescribed by Family Code, but one of the spouses leaving the family may file an application for divorce in the registry office or without a valid reason, even for state registration of a divorce, accordingly without informing in writing about the consent to register a divorce in his or her absence for a good reason. Therefore, the second spouse is forced to file a lawsuit. In this case, a dispute arises between the persons, which must be resolved by the court in the course of action proceedings. In case of dissolution of the marriage through a claim proceeding, in the statement of claim in particular, there must be reasonable grounds for divorce in court and the presence of obstacles to divorce in an administrative manner. It is necessary to understand that a divorce through the court can last from 1 to 6 months. Contact a competent family lawyer and he will do everything possible to shorten the processing time for a divorce claim. Divorce procedure on a common application of the spouses through the court. Family Code provides the possibility of spouses with children to dissolve the marriage in this manner under the following conditions: filing a common application, the presence of mutual consent for divorce, as well as mutual certainty and consistency of such issues. Which of the parents the children will live with, what kind of participation in ensuring their living conditions will be, the one who will live separately, as well as on the conditions for exercising his right to personal education of children. Submission together with a statement or a written agreement on which of the parents the children will live with. What kind of participation in ensuring their living conditions will be taken by the parent who will live separately, as well as on the conditions for exercising his right to personal upbringing of children. The contract must be separated from the contract on the exercise of parental rights and the fulfillment of duties by those of the parents who live separately from the child, which differs in that it is not related to the dissolution of marriage between the parents of the child, who may not be at all married and is subject to notarization. Family Code establishes the procedure according to which a married couple should submit a notarized agreement on the amount of alimony for a child, justifying the need for notarization with the subsequent opportunity to collect alimony on the basis of a notary's executive note in case of failure to fulfill this agreement. How long does it take to file a divorce? The administrative procedure of divorce formalizes as fast as possible and takes a calendar month from the date of application, but has strict conditions that may contradict the life circumstances of the applicants. The judicial procedure is more complex and lasts from 1 month to 6 months, depending on the presence of children, the objections of the second part of the couple, followed by abuse of procedural rights. The issue of divorce in court is quite delicate and requires appropriate knowledge of family and procedural law. Respectively, the best solution is to seek help from a divorce lawyer. When is it impossible to file for divorce? Family Code establishes restrictions on the possibility of filing a claim for divorce, namely, during the pregnancy of the wife, within 1 year after the birth of the child. If there are errors in the statement of claim, the period for considering divorce is also increased. According to the resolution of the Supreme Court of Ukraine on the practice of applying legislation by courts when considering cases on the right to marriage, divorce, invalidation and division of common property, this restriction applies to both men and women, including cases when a child was born still or died before reaching their 1 year old. Divorce procedure exceptions. Exceptions to this rule are making on an illegal act by one part of the married couple which contains signs of a criminal violation in relation to the second of the spouses or the child. Considering the dissolution of the marriage in a special procedure, according to Family Code and action proceedings, it should be borne in mind that the limitation of the article of Family Code concerns precisely the filing of a claim for divorce. So the issue of the divorce in accordance with the Family Code may be considered only when the child reaches 1 year. In making the appeal decision, the Court of First Instance proceeded from the fact that in accordance with the Civil Procedure Code, The application is returned in cases where the application for divorce is filed during the wife's pregnancy or before the child reaches 1 year old without complying with the requirements established by the family code. However, the court didn't take into account that these provisions relate specifically to the statement of claim, which is considered in the course of action proceedings, whereas the applicants applied to the court with a common application for divorce, which should be considered in a special proceeding. Consulting a professional divorce lawyer is a guarantee of your success. Contact the lawyers of our company in any way convenient for you. Call or write to messengers. We'll help you to resolve all issues quickly and efficiently. If you have a need for a consultation or paid services of a lawyer, then contact the contacts listed under this video. If you have any questions, then write them into the comments to this video and I will definitely answer you. If this video was useful for you and you learned something new about the procedure for divorce with or without children, then like this video, subscribe to my channel, share with friends, press the bell so as not to miss new videos. See you in new videos.